Dear friends, does the President of India has the powers to override a Supreme Court ruling or not? The answer is a big no. But the President of India under Article 143 of the Indian Constitution allows the President to refer a matter of law to the Supreme Court of India for its opinion. Then the Supreme Court of India gives an advisory opinion which is not legally binding. What is a legally binding is this: the Supreme Court is the final arbiter or on all legal matters in India, and its decisions are binding on all courts and all authorities, including the President of India. Then what is the way forward? The only way to alter a Supreme Court ruling is through an amendment to the Constitution, which requires a majority in both the houses of Parliament. And while a Parliament ruling can be reviewed by the court itself, there is no mechanism for the President to initiate a review. What is worrying is the President has framed 14 questions to the Supreme Court of India to give its opinion, which was already settled by the Supreme Court of India in the division bench of the Supreme Court of India in a clear-cut and categorical manner in a 415 pages judicial documents. All the questions have been summarily answered by the Supreme Court, and the Constitution gives the ways for that. The questions posed by the President of India are these: what are the constitutional options before a governor when a bill is presented to him under Article 200? Is governor bound by the aid and advice tendered by the Council of Ministers while existing all the options available with him when a bill is presented before him? Is the constitutional discretion by the governor under Article 200 is justifiable? Is Article 361 an absolute bar to judicial review in relation to actions of a governor under Article 200? These are the questions posed by the President of India to the Supreme Court of India to give its opinion on all this matter. To all the questions posed by the President of India, the Supreme Court of India has answered all the questions in a categorical manner in its 415 pages of the judicial document in a clear-cut manner. But without these things by the central government of making either constitutional amendment or approaching the Supreme Court of India for a larger bench, that is a constitutional bench, or some other review of the petition, it is using or misusing the office of the President of India. It will not work out. It is not good for the health of Indian democracy. Indian democracy is maintained and managed by the Constitution of India. The Supreme Court of India is the interpreter and arbiter of the constitutional matters. Hence, the President has no powers to override the rule given by the Supreme Court of India in any way. This is our understanding. Our humble request is to the President of India is this: the business of doing all these things, challenging the Supreme Court of India, rests with the Union government, not with the office of the President of India. This is our message. Thank you so much.